Live from the drama-free true crime destination. No distractions, no detours, just the facts, the fire, and the focus you deserve. This is Saturday night's main event. All right, sorry about the delay, but had a little issue with the opening here, but still I am here. I am ready to get going. Welcome everybody to Saturday night's main event, where headlines meet justice, and we're all about accountability here. Yeah, every verdict tells a story of accountability. I'm Ernest Bethea, the last outlaw, and tonight we've got a loaded lineup that demands your attention. Here's what we got. An ex-teacher is sentenced for sex crimes involving an incarcerated minor. A man is convicted in the brutal murder of a Montana campsite. Former NFL star Antonio Brown is released from jail after posting bond. A woman is charged in the killing of her husband at a South Carolina facility, and she's been granted bond. John Skelton is charged with the murder of his three sons who have been missing since 2010. A Tennessee man is charged with murdering a woman by setting her on fire. A man in Minnesota is accused of murdering his female co-worker with a sledgehammer. The attorney for rapper Cardi B fires back as Cardi's accuser's lawyer admits inexperience. We have verdicts in the Love Triangle beheading trial, Nevada versus Devin Michaels, and a verdict in the adopted son murder trial, Florida versus Dima Tower. Convicted killer Brian Koberger has been ordered to pay restitution to the victims' families. A former deputy officer's apology as he is sentenced to the manslaughter death of his girlfriend. Brian Walsh has been deemed competent and he's ready to stand trial in his wife's murder. Dakota Van Patten is sentenced in the machete murder plot trial. A confessed hitman changes his story about the murder of a Microsoft executive, and police say a man murdered two others inside a Michigan car dealership over a $3,000 dispute. That's all coming up tonight on Saturday night's main event. We're going to kick things off in true Bethea'S Byte reloaded fashion with my opening statement. Tonight, we gather not for spectacle, but for sober reflection. From classrooms betrayed to families shattered, from verdicts rendered to sentences handed down, these headlines remind us that justice is lived, painful, and necessary. Each case is more than a headline. It is a testimony of choices, consequences, and accountability. So now, without any further delay, let's go ahead and get started, where an ex-teacher is sentenced for sex crimes involving an incarcerated minor. Let me get that link so I can pull it up for you guys here. And here we go. All right, all right, all right. And everything. You know how technology is can be slower than molasses at times. Oh no, you not. All right. So the video doesn't want to play. No problem. We're going to kick things off in Adair County, Kentucky. A former teacher was sentenced to a total of 14 years in prison on Thursday after a jury convicted her of sex crimes involving an incarcerated minor. In September, 27-year-old Elena Barden was convicted of one count each of first-degree sexual abuse, unlawful transaction with a minor, and distribution of obscene material to a minor. The jury recommended that she be sentenced to a total of 14 years in prison. The judge ultimately agreed with the jury and sentenced Barden to 4 years in prison for first degree sexual abuse and 10 years for unlawful transaction with a minor to be served consecutively. Additionally, Barden was given 12 months for distribution of obscene material to a minor to be conserved concurrently. And she must register as a sex offender for 20 years. Boy, her life is messed up. Prosecutors accused Barden of having a sexual relationship with a 17-year-old student at a juvenile detention center where she was serving as an English teacher. Barden was also accused of soliciting the minor to kill her husband, but the jury acquitted her on that charge. The juvenile victim testified at trial that he never intended to act on Barden's comments about having her husband killed, and that their relationship was just a way to kill time while he was locked up. That's according to the Lexington Herald Leader. Barden's former colleagues testified at trial that they were suspicious of Barden's relationship with the juvenile victim, and the victim was even moved to prevent their continued contact. The judge said that at sentencing. Barden was arrested in April after a search of the juvenile served cell turned up letters and explicit material provided by Barden. At sentencing, the judge noted that Barden sent over 190 letters to the juvenile victim, and one in particular in which she admitted to her crimes resulted in her conviction. Well, this is what happens when you put yourself out there to that point, knowing you're going to cross some boundaries. But you go ahead and do it anyway, and the end result, you're getting locked. You're going to be right behind. You're going to be locked up behind bars, albeit in a different facility. But you're going to be locked up with your juvenile boyfriend. That was pretty smart of you, Ms. Barden. Good luck. Good luck to whatever comes next during your prison stay. All right. Next up, we got a conviction going here. Let's file this one under justice served. A man is convicted in a brutal murder at a Montana campsite. All right, there you go. Bozeman, Montana. A jury has convicted Darren Christopher Abbey on charges of deliberate homicide and tampering with or fabricating physical evidence in the killing of Dustin Cursum. Prosecutors accused Abbey of murdering Cursum in October 2024 at a evidence after guys. It's coming from your room, babe. Are you trying to destroy it? Babe, it was coming from your room. Okay. Okay. Anyway, back to this. According to charging documents, Cursum's girlfriend found him dead in his tent the next day after he failed to return to town after camping. Detectives reported chop-like injuries to his body. His death was first thought to have been caused by a bear attack, but an autopsy performed days later determined it was homicide. Investigators collected items from the scene, including beer cans and shot glasses, and sent them to a Montana crime lab. DNA testing tied the evidence to Abbey and his twin brother Dustin, who was incarcerated at the time. After identifying Darren as a suspect, Butte police detained him on a probation violation. Abbey allegedly said he struck Cursum on the head with a piece of firewood, stabbed him in the neck with a screwdriver, and hit him on the face with the blunt side of an axe. Charging documents also said Abbey admitted to taking numerous items that had his fingerprints on them, including 2 coolers, a .44 Magnum pistol and holster, a shotgun, and a shotgun ammunition sleeve. He reportedly admitted to washing the axe and screwdriver in the creek. During closing arguments, prosecutors told jurors Abbey should be found guilty because he tried to hide evidence, showing photos of Abbey posing with firearms that they said were stolen from Cursum after the killing. Prosecutors also argued Abbey used excessive force. He said in his interview he was aiming for his head, the prosecutor said. You may find in deliberation that it was spot on. It was accurate, and it was hard, and it was powerful. The prosecutor added that on November 10th, the day of the verdict, would have 1 second, guys. I'm trying to get this over. Okay. The prosecutor added that November 10th, the day of the verdict, would have been Cursum's 37th birthday. Abbey's defense attorney argued that he acted in self-defense after being threatened at gunpoint, saying fear and adrenaline surged as Darren Abbey faced a gun threatening him and his dog. The defense also criticized the Gallatin County Sheriff's Office, telling jurors the investigation and handling of evidence was flawed, asking, when can we the people trust law enforcement? The verdict came Monday afternoon after 6 days of testimony and 3 hours of jury deliberations. Abbey's sentence is scheduled for December 30th. Let's see. He was fearing for his life. So he killed this man. Let me see. He killed this man using... So he struck him in the head with a piece of firewood, stabbed him in the neck with a screwdriver, and hit him in the face with the blunt side of an axe. But he was in fear for his life. Guys, who is he? Who does he think he's kidding here? I mean, that's one of those I was born at night, just not last night type situations. Just saying. December 30th, we'll find out exactly what his fate's gonna be. Right now, we're gonna see former NFL star Antonio Brown being released from jail after posting bond. As you all know, Brown is facing attempted murder charges. Let's see if we'll get a video to play for this story. Eh, the answer is yes, but it's rather short. So I'm just going to go ahead and move onward with the story in itself. Miami, Florida. Former NFL star wide receiver Antonio Brown walked out of a Miami jail on Thursday, released on $25,000 bail after pleading not guilty to a second-degree attempted murder charge. The 37-year-old Brown, Guilford Knight Correctional Center in Miami. He held a bag of belongings as they walked to a nearby food truck where Brown got a drink, and then they left in the lawyer's vehicle. Circuit Judge Mindy Glazer ordered Brown to wear a GPS ankle monitor as he awaits trial. Well, I guess not. It wouldn't have played anyway.
Soon, but we do have some developments in another story we've been following. This is about
the audio will play, but the video will not. Oh boy. Okay, let me see what else I can do before I continue with this article. This is on my end, guys. So my apologies for the delay, and hopefully we'll get this thing straightened out. All right. All right. Okay, let's try this one more time. Hey. All right. We got a Ford TV for for the developments in the Antonio Brown saga.
soon, but we do have some developments in another story we've been following. This is about former NFL star Antonio Brown. He is out of jail after posting $25,000 bail. Brown hugged his attorney outside the Miami jail. He is charged in connection with a shooting incident in Miami that took place earlier this year, where he allegedly fired 2 shots. The victim claims one of the bullets grazed his neck. Brown has pleaded not guilty. He must also wear a GPS ankle monitor. We will keep you posted on any new developments in that case. We'll be right back with more after this quick break.
My thanks to Court TV's Kelly Crabb for that update. And here is the rest of the article from the top. As you heard, Antonio Brown walked out of Miami jail Thursday, released on $25,000 bail after pleading not guilty to second-degree attempted murder. 37-year-old Brown embraced attorney Mark Aglash outside of the Turner Guilford Knight Correctional Center in Miami. He held a bag of belongings. They walked to a nearby food truck where Brown got a drink, and they left in the lawyer's vehicle. Circuit Judge Mindy Glazer ordered Brown to wear a GPS ankle monitor as he awaits his trial. He faces a potential 15-year sentence and a fine of up to $10,000 if he's convicted. Prosecutors that sought pretrial detention contending Brown is a high-paid former professional athlete with resources to flee. Eyeglass, who told the judge on Wednesday that Brown, who no longer has a passport, would return to his home in Broward County, Florida, while the case proceeds. Brown is accused of, as Kelly just mentioned, he's accused of grabbing a handgun from a security staffer after a celebrity boxing match in Miami on May 16th and firing 2 shots at a man he had gotten into a fist fight with earlier. According to an arrest warrant, Zulkarnain Kwame Natambu, if I mispronounce the name, please hold it to my head and not to my heart. He told investigators that one of the bullets grazed his neck. Brown's attorney said Wednesday that the affidavit is mistaken. Brown actually used his own personal firearm, and the shots were not aimed at anyone. Brown spent 12 years in the NFL and was an all-pro wide receiver who last played in 2021 for the Tampa Bay Buccaneers. He spent much of his career with the Pittsburgh Steelers. For his career, Brown had 928 receptions for more than 12,000 yards and 88 total touchdowns. That's counting both punt returns and 1 completed pass. Now, Brown has the matchup of his entire life on the line. Well, not his entire life, just the next 15 years of it. We'll see how that plays out as this case continues. All right. Another bond that has been granted, this time to a woman who's charged in her husband's killing in South Carolina. Oh boy. All right. This is what we got next up on Saturday night's main event.
Here's the forecast for tomorrow. Look for showers with a high of 56 degrees Fahrenheit and a low of 47 degrees.
That's my Amazon Echo with the weather update for tomorrow. We're in Beaufort County, South Carolina. Has been granted bond according to court records. In September, 82-year-old Harriet Recker, who you see on the left side of your screen, has been charged with murder and possession of a weapon during the commission of a violent crime, according to the Beaufort County Sheriff's Office. Authorities allege she fatally shot her 81-year-old husband at the Preston Health Center in the Cypress of Hilton Head. That's according to WJCL, who identified the victim as Dennis Record. According to court documents cited by WTOC, Harriet's bond of $50,000 was set with the condition that she may live with her son in Hawaii. Investigators believe the killing was premeditated due to notes found in Harriet's purse and home. That's according to a previous report from WCSC. A note read during a previous court proceeding allegedly said, "To you all, this has just been too much for me. I so wish I could do it with a wonderful family we have. So many good friends. We can't have a life without someone, and that someone can't be me, as I am not strong enough or smart enough to do all this." Court records do not indicate a future hearing date. So, knowing that, I can't say one way or the other until I hear more out of this case. So we're gonna continue this whenever I get updates on it. All right, let's see what we got next up on this docket. John Skelton. John Skelton. Just when he thought he was getting out, he gets hit with a charge of murdering his three sons, all three who have been missing since 2010. All right, let's get to this report. All right. We're going to take you right back to Court TV for this update on John Skelton's case.
Breaking news that is taking place in the state of Michigan. The father of three brothers who went missing in 2010 has just been charged with their murder. With evidence. These charges coming just days after it was announced he would be released from prison for the unlawful imprisonment of the boys. Earlier this year, a judge ruled that the three brothers, Andrew, Alexander, and Tanner, were legally dead. This came after a request from the boys' mother. Police released age progression photos of the boys because John Skelton claimed the boys were handed to other people for their safety. After an intense investigation, the police said that claim was false. We will bring you more developments on this story as soon as we get them.
Sure as Court TV gets that information, as will Bethea'S Byte Reloaded. But for now, this is the information we got on these murder charges. John Skelton, the father of three brothers who went missing in Lewanee County in Michigan in 2010, is been charged with murder. The 53-year-old Skelton was charged Thursday in Lenawee County Court with 3 counts of open murder and 3 counts of tampering with evidence. Earlier this year, a judge ruled that the three brothers, Andrew, Alexander, and Tanner, were legally dead. It came from after a request from the boys' mother, Tana Zilvers. Their death date was set as November 26, 2010. This is a case of terrible and long-standing impact on the community of Lenawee, Judge Catherine Salas said. No condolences will ever be enough for such loss suffered. Skelton was set to be released from prison later this month after serving 15 years for his failure to return the boys to Zoovers. Skelton and Zoovers were having problems and living apart in Morenci. The boys were supposed to go back to their mom the next day. Instead, they were gone. They have not been found, despite numerous searches of woods and water in Michigan and Ohio, as well as tips from across the country. Police said Skelton fed them a long string of lies about the boys' whereabouts, sending investigators to an old schoolhouse in Kunkel, Ohio, and a dumpster in Holiday City, Ohio. Police said the boys were handed to other people for their safety also turned out to be false. He also declined to participate in the hearing, saying, "Anything I say isn't going to make a difference." Well, that's some defense. That's some defense, especially when it's his boys, his sons. But hey, keep doing you, buddy. By the time this goes to trial, it might be a quick beginning and a quicker end. Next up, we're going to go to Tennessee, where a man has been charged with murdering a woman by setting her on fire. We are in Hamilton County, Tennessee with this one. A Tennessee man is facing charges including murder and arson after he allegedly set a woman on fire. Investigators say Christopher Allen Medulla, age 39, whom you see on the right-hand side of your screen here, tried to flee the scene after the attack, but was detained by a witness at gunpoint. Deputies with the Hamilton County Sheriff's Office responded to the scene on Cliff Eldridge Road on November 11th after receiving a call that a suspect had set his grandmother on fire. His grandmother. The victim was lying on the driveway when officers arrived, with severe burns covering most of her body. With her last breaths, she told officers, "Chris did it. He poured gas on me, and he's lost it," in statements recorded by a deputy's body-worn camera. Investigators later identified the victim as Angela Michelle Palacio, who died from her injuries, and said, despite earlier reports, there is no known familial connection between him and Medulla. The witness who held Medulla at gunpoint told police that he was inside his own camper a few lots down when he heard screaming and drove over to help. The witness reported seeing Medulla attacking the victim, who was covered in flames and burns. Upon seeing the witness, Medulla allegedly first tried to hide, then made statements including, "I had to do it. She's the devil, and I'm Jesus." Oh boy. When deputies approached Medulla and gave him a Miranda warning, he immediately responded saying, "I had to do it. She was evil, and she raped me." In an interview with detectives, Medulla allegedly admitted to the attack, saying he poured gasoline on Palacio and set her on fire with a cigarette lighter. A lighter was found in his pocket. Court records indicate Medulla is scheduled to return to court on November 17th, this Monday. What could this woman have done for him to set her on fire? He set her on fire. I've covered in the 3+ years I've been doing this. In the 3+ years I've been doing this true crime thing, I have seen and I have heard of a lot of gruesome murders. But this, my friend, It's just absolutely brutal. And I hope and I pray that the next thing that happens will be this woman getting justice, and this guy Medulla getting put behind bars for good. Next up, a Minnesota man is accused of murdering his female co-worker with a sledgehammer. I maybe looks like I might end up being asking the same question. What could this woman have done? We're in Wright County, Minnesota. A man is accused of fatally beating his female co-worker with a sledgehammer on Tuesday. 40-year-old David DeLong, whom you see here, is charged with second-degree murder in the attack that was caught on surveillance video, according to a probable cause statement obtained by Court TV. The victim was identified as 20-year-old Amber Sheck, which is reported by CBS News. DeLong and Sheck were employees at Advanced Process Technologies in Cocoto, a facility that manufactures products for food and dairy processing. Surveillance video allegedly shows DeLong approach Check's workstation and grab a sledgehammer before swinging it multiple times. Check's body was found near her workstation with very significant head trauma and substantial blood loss, according to documents. The sledgehammer was also found nearby. After the attack, allegedly told another coworker, "I hit her with your hammer. She is by your toolbox. She's gone." DeLong also allegedly confessed to the killing after being advised of his rights. Authorities say he admitted to not liking Check and that he had been planning to kill her for some time. Check's family told KARE that she was hardworking, helped anyone in need, and loved her job as a welder. Second degree murder carries a minimum sentence of 40 years. Oh, excuse me, a maximum sentence of 40 years, according to prosecutors. DeLong is due in court in 2 weeks, November 24th. And just as sure as I said I was going to ask this question, here I am asking it. What could Amber Check have done to this man that, one, made him dislike her, and two, plan to kill her for how long? For some time. He planned on killing her for some time. But for what? It's mind-boggling. All I can pray is that Amber gets justice, and this guy who will is likely going to plead out gets his gets the time that he deserves. Next up, Cardi B's attorney is firing back as the lawyer for Cardi B's accuser admits inexperience. This is going to be interesting. We're going all the way to Los Angeles. The woman who lost her lawsuit against rapper Cardi B is asking a judge to give her another chance as her attorney faces fallout from his behavior during the trial. Cardi B, real name Belcalis Marlenis Almanzar, successfully defended herself against a lawsuit brought against her by security guard Imani Ellis, who accused the WAP rapper of assault and battery following an incident at a Beverly Hills doctor's office. Both Ellis and Cardi B testified. But after 4 days of trial, the jury sided with Cardi B and denied Ellis's claims. In her motion for a new trial, Ellis focuses less on what happened inside the courtroom and more on what happened in the hallways and courtroom steps. In an incident caught on camera, Cardi B threw a pen on the courtroom steps. In the motion for a new trial, Ellis's attorney, Ron A. Rosen Janfanza, suggested the behavior should merit a new trial. The incident happened while she was on a lunch break during the trial. The incident caused another individual to get pushed and injured. It was also completely unlawful and disrespectful for the defendant to injure others during the trial on the Alhambra courthouse property, which she did on September 2nd, 2025. Additional time is needed to determine if the defendant's actions of throwing a pen at a man outside the Alhambra courthouse were witnessed by the jury. In response, calling the motion for a new trial entirely frivolous, Cardi B's attorney, Peter Anderson, questioned why any juror would have been standing outside the courthouse with a gaggle of press. The tension in the case extends beyond Cardi B and Ellis, as their attorneys have now filed dueling requests for sanctions, each accusing the other of unethical behavior during the trial. Janfanza, in the motion for a new trial, accuses Anderson of threatening him to obtain an advantage, and also of assaulting him in a hallway of the courthouse during the trial. Anderson dismissed the claims on Cardi B's response, noting that sheriff's deputies were present at all times in the hallways and never reported any assault, shouting, or other incident. Meanwhile, Anderson filed a motion for an order to show cause, compelling Janfanza to provide proof as to why he should not be held in contempt or sanctioned for his behavior during the trial. The issues Anderson focused on in his motion included Janfanza asking questions that were previously deemed to be outside the scope of acceptable evidence and violating other court orders during the trial. Janfanza penned an exhaustive response to the motion, pleading with the judge to give plaintiff's counsel the benefit of the doubt. He explained that he wasn't a seasoned trial attorney like Anderson, and any mistakes were purely accidental. Janfanza explained that he had only gone to trial in 10 cases before this. Plaintiff's counsel took this case on from another firm for the sole reason of giving the plaintiff an opportunity to be heard. Plaintiff's counsel has already lost thousands of dollars in that pursuit, even though he is struggling financially. Plaintiff's counsel's future career path is to be a judge in an effort to help other people by administering justice. Janfanza also notes he plans to take a trial advocacy class to better understand how to proceed to trial. A hearing is scheduled on the order to show cause and the motion for a new trial on December 5th. And in my opinion, I don't think that case that motion is going to get anywhere fast, especially with an attorney claiming inexperienced. Are you serious? If there's anybody that was involved in this trial that should claim any kind of inexperience, it would likely be Cardi B if she was defending herself. I mean, she's a rapper, not a lawyer. The lawyer that's claiming inexperience, that's ay ay ay. If you didn't have the experience, why take the case? I got my opinion before I move on to the next case on the docket. I believe that that motion for a new trial is going to get laughed right out of the courtroom. And that's all I've got to say about that one. Next up, the verdict is in the love triangle beheading murder trial. State of Nevada versus Devin Michaels. We are going to take you right into the courtroom for that verdict. As soon as I get set up good here. Oh, no, I guess not. We're not going to have a video for this. So I'm just going to go ahead and straight up give you the information that we have. A former adult film star faces 51 years to life in prison after a jury convicted her of bludgeoning and decapitating her ex-boyfriend as he prepared to move into her Las Vegas home. 47-year-old Devin Michaels was convicted of murder with the use of a deadly weapon in the death of Jonathan Willett, the father of her two daughters. The case centered on what prosecutors described as a brutal killing that occurred as Willett was moving into Michael's home on August 7, 2023. During opening statements, prosecutors told jurors that Michaels killed 46-year-old Willett because she was unhappy with how quickly he was moving in with her and their daughters. The former couple had discussed the living arrangements months earlier as a way to keep their family together. But investigators believe Michaels became concerned that Willett's presence would disrupt the home life she had established with her husband, DeVere Willett, Jonathan's son from a previous relationship. Both Michaels and DeVere told police that their marriage was out of convenience for insurance. However, it was later revealed that they had been carrying on an affair for years while Michaels was dating Jonathan. According to the prosecution, Michaels confessed to police that she clubbed Jonathan over the head while he was lying on his stomach receiving a massage. However, she denied decapitating him and hiding his head, despite evidence suggesting otherwise. Police have not been able to recover Jonathan's head or the murder weapon. Defense attorneys have presented a dramatically different theory of the crime, pointing their finger at DeVere. The defense claims that DeVere killed his father out of the fear that the move would mean losing Devin and their home. Court records show that Michaels, also known as Tracy Tavares, was once married to Robert Louis Baker, who was convicted in California of murdering Fabio Samatelli with his lover, Monica Samatelli. The judge set Michaels' sentencing date for January 8th, 2026. Devin Michaels, convicted of, of murder, and now she is literally staring at 51 years to life in prison. This is crazy, man. We'll see what happens come January when her sentencing date arrives. From one verdict watch to another, we're gonna go all the way from Nevada to Florida for the adopted son murder trial verdict. State of Florida versus Dima Tower. All right, let's see. Ooh. Will we get to the verdict? Yeah. Oh, that's day 3? Oh, I think we will get to that verdict after all. All right, guys. Stand by. Once I get this all set up here, you'll hear the verdict directly. Florida versus Dima Tower.
Be seated, everyone. Good afternoon. 2 more minutes, I guess. All right, Deputy, I'm told we have a verdict. Is that right?
Yes, Your Honor.
All right, we have everybody present. Are both sides ready to bring the jurors back in?
Yes, Your Honor. Yes, Your Honor.
All right, let me just caution everybody in the audience, we're going to respect the verdict, whatever it is, by this jury. So please, similar to what we talked about earlier, no outward signs of emotion or comments. We need to be professional, respect the jury. So if you can't handle it, then I need you to remove yourself kindly, okay? All right, let's bring the jurors in.
All rise, jurors entering.
All right, welcome back, everybody. Everybody may be seated. Members of the jury, I'm told that you reached a verdict. Is that correct?
Yes.
Can the foreperson hand it to the bailiff? I take a look at it next to make sure that it's executed, signed, and dated, etc. And then I'll hand it to the clerk. Can you please hand this to the clerk? And the clerk is going to publish the verdict.
In the Circuit Court of the 12th Judicial Circuit in and for Sarasota County, Florida, State of Florida versus Dima Tower, case number 2023 CF 8812NC. Verdict. We, the jury, find as follows as to count 1, victim Jennifer Tower. The defendant is guilty of murder in the first degree as charged. We, the jury, find as follows as to count 2, the victim, Robbie Tower. The defendant is guilty of murder in the first degree as charged. We, the jury, find as follows as to count 3, the defendant is guilty of fleeing to elude a law enforcement officer as charged. So say we all this 14th day of November 2025, signed 4%.
Members of the jury, there's something we do after every verdict. It's called polling the jury. So what I'm going to do is I'm going to start in the back. I'll go left to right, then I'll come forward and go left to right, okay? So to the gentleman in the back left, is this your verdict and the verdict of the jury as a whole?
Yes.
To the gentleman next door, is this your verdict and the verdict of the jury as the whole?
Yes.
Ma'am, is this your verdict and the verdict of the jury as a whole?
Yes.
Ma'am, is this your verdict and the verdict of the jury as a whole?
Yes.
Young lady on the far right, is this your verdict and the verdict of the jury as a whole? To the gentleman in front, is this your verdict?
Yes.
Next gentleman, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
And ma'am, is this your verdict? Folks, on behalf of everybody, I want to thank you for your service. We have different types of trials. This was a longer trial, although as I mentioned, not terribly long. We do have those that are longer. We asked a lot of you. You came in Monday on a week with a holiday. You were here all week, early in the morning. So we all truly appreciate your service. The system cannot function without you folks, and I talked a lot about that on Monday, so thank you. You have a right as a juror not to discuss your jury service with anybody. That's a right you have as a juror. It would take a court order to compel it. I haven't seen it in my career done. You also have the ability to speak to whoever you want. That's a right you have as a juror as well. No one can prevent you from speaking. I know it's a big ask, again, Monday through Friday. I hope the experience was good for you. We try to be as efficient as possible with your time and not get you in and out as efficiently as possible. So again, thank you. Your service is done. What I'm going to do after you leave is I'm going to talk to the parties. We'll discuss setting a sentencing date. I don't know if we're going to do that today or if we're going to do it down the road. You're welcome to stay. You're welcome to leave. You have no further obligation to the court. I think it gets you out of jury service for a year. So there's some good news. But again, thank you. Make sure you take all your personal belongings with you when you leave. If you want to find out what happened or what happens, you can give my judicial assistant a call, Jennifer. Her number's on the board, I believe, in your jury room. You can give her a call later today and find out what the next steps are, okay? Thank you so much, everybody, for your service. Can everybody please stand? Our jurors are now exiting the courtroom.
All right.
All right, let's take I'm going to take a 2-minute break. I'm going to go thank the jurors for their service in the jury room. Why don't let's leave Mr. Let's handcuff him. Let's leave him in here for now. Why don't you talk among yourselves when you want to do sentencing, how you want that to take.
There you have it. Dima Tower found guilty on all counts related to the murders of Robbie and Jennifer Tower. And in a way, this affects me a little bit because I am an adopted son, and I know that I appreciate both of my adopted parents, and that would be the very last thing I would do when it comes to my mother and my father, the ones who literally took me into their lives, saved my own life in the process. So for me to hear this and cover this, because for some crazy reason that he wanted to, he went ahead and killed his adopted mother and father. Yeah, I am going to try to get you right to the sentencing of Dima Tower, because he was not only was he found guilty, but he was sentenced that very day. So give me one moment, guys.
There are a lot of
Efficiently, lawfully, which is our roles in the judicial system. We serve a function and we need to make sure that happens. And so I appreciate your role in that. As the judge, I don't know the folks that are murdered or injured in cases. You realize I come into the story much later, at a trial often, or at a sentencing hearing. I can tell you that the role of a judge is very difficult sentencing most days. I anguish over sentencing decisions I have to make. I do it on a daily basis, 5 days a week, handling all types of different cases, and have to make decisions as to whether someone goes to jail or not, or goes to prison or not, and if so, how long. And I think you can imagine in many cases, most cases, that can be difficult. You see the human compassion in people, and you see mistakes can be made. Today, obviously, is not one of those days for me. Sentencing today is very easy, and I think it was Miss Lisa Huff, or actually no, it might have been Laura Ely, I'm not sure, maybe both, who had great insight in their statements that there's a role that the court has, and that is to punish and also to provide for the safety of the community. What I enjoyed this afternoon was, even though it was brief, learning about the terrific lives that this, I'm going to call them Robbie and Jennifer, lived. They seemed, and many of you used these words, that they were selfless. Some of you said that they gave the shirt off their back for others. They ministered to children and others, going as far as Ukraine and Russia to help those in need in South America. They were babysitters. They were a happy husband and wife. They were children to the parents we heard from, brothers, aunts, uncles. They just really seemed like terrific people. And it is a shame that in this great country that we live in, that we lost two shining stars. I hope that, and one of you mentioned this, that they live on in your hearts, in your memory, and I hope you realize that. I know you do. The grief, the anger will continue for time, but I hope you cherish, and I know you will, those memories and lean on each other and the love and support of your family, and celebrate what seems to be amazing lives of two great people, and they can be beacons for how you teach your children and how you continue to move on. Mr. Tower, I don't know what else to say. You seem to be an evil spirit, an evil person.
Evil spirit because you're talking foolish.
Who doesn't seem to have any
I'm full of remorse. I'm not showing it because
I will at this time,
Professor.
Mr. Tower, sentence you as to count 1. This is for first-degree murder of, count 1 was Robbie, is that right?
Yeah.
Of Robbie.
Proper name is Robbie.
Of Robbie Tower. I will sentence you to life in prison. You will serve the rest of your life in prison without the possibility of parole. Count 2, and often I do run them concurrent. I know that the defense requested that. We have a unique and clearly a special life in Jennifer Tower as well, and I spoke about that earlier. I'm going to adjudicate you guilty of count 2, first-degree premeditated murder on Jennifer Tower. I will run this sentence consecutive to count 1. I will sentence you, Mr. Tower, to life in prison without the possibility of parole. Count 3, the fleeing or attempting to elude law enforcement with lights and sirens. I'll adjudicate you guilty. Let's see, this is what degree felony? State third. Sentence you to the maximum of 5 years in prison to run concurrent with count 2. I will order that you have no contact whatsoever with Robbie and Jennifer's family, aunts, uncles, cousins, nephews, parents, siblings. I will order restitution and reserve as to the amount. I'll order as a civil judgment against you court costs, a prosecutor fee and public defender fee of $100 to each. Are there any other statutory terms that I'm leaving out? State.
No, Your Honor, but I do have a score sheet for count 3, which is the only count that requires a score sheet.
Mr. Gilman, anything I left out?
No, Your Honor.
All right, Mr. Tower, you have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that appeal, one will be appointed to represent you.
what about the truth?
Good luck to everyone. Court will be adjourned.
And there you have it. And there you have it, folks. Dima Tower will be spending the rest of his life behind bars. Officially, it's 2 consecutive life sentences. Now, I know if my wife were here right now, here listening to this, she would say he's only got but 1 life, which is fact. But legally, when you're hit with two life sentences, yeah, that's a certainty that he will be spending the rest of his natural life behind bars with no possibility of parole. Dima Tower, that's the bed you made. Now you're gonna have to lie in it. Ladies and gentlemen, let's call that what it is. Justice served. Next up, speaking of convicted killers, this one is Brian Kohlberger. You all know him. He was the guy that killed those four University of Idaho students, and was convicted and took a plea deal to avoid the death penalty. So now, Mr. Kohlberger has been ordered by the court. If I can get that link, he's been ordered by the court to pay restitution to all of the families of the lives he took. Well, we're in Boise, Idaho. Brian Kohlberger has been ordered to pay more than $3,000 in restitution to the families of two University of Idaho murder victims, despite his defense team's arguments that he cannot afford the payments while serving consecutive life sentences. District Judge Stephen Hippler issued orders on November 13, 2025, requiring Kohlberger to pay $1,420 to Stephen and Christy Gonsalves, the parents of Kaylee Gonsalves, and $1,587 to Karen Laramie, the mother of Madison Mogan. The payments are specifically for earnest purchase for their daughter's remains. The court rejected Kohlberger's argument that he should not be required to pay restitution due to his inability to earn money while incarcerated. Judge Hippler noted that Kohlberger had received $28,360.96 in donations while in custody and could potentially earn money through prison employment programs. The judge found that Kohlberger's age, minimal living expenses in prison, and the likelihood of future donations or prison wages make it foreseeable that he could satisfy the restitution over time. The restitution orders stem from Kohlberger's plea agreement, which specifically allowed the state to seek compensation for funeral expenses. The agreement states that the state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in the amount to be determined. This provision bypassed the court's usual analysis of a defendant's ability to pay according to the judge's order. Court documents reveal Kohlberger faces significant financial obligations totaling over $300,000. Criminal fines and fees of over $250,000, $251,227.50. Civil judgments of $20,000 for each victim's family. Previously ordered restitution of $31,964.67 to crime victims' compensation and other families. And the new restitution orders totaling $3,007.79. The prosecution originally sought restitution for travel and accommodation expenses incurred by families attending court proceedings, but withdrew this request during oral arguments. The court noted these costs were not covered under the plea agreement terms. The restitution orders carry a 9.125% annual interest and are payable through Ada County Clerk's Office. Kohlberger was charged in the November 2022 murders of 4 University of Idaho students, Kaylee, Madison, Xander Kernodle, and Ethan Chapin. The case drew national attention and resulted in Kohlberger receiving consecutive life sentences without the possibility of parole after pleading guilty to the murders in September 2025. Bottom line, looks like Mr. Kohlberger's going to have to pay up. Period. Next up, an ex-deputy offers his apology as he's being sentenced for manslaughter in his girlfriend's death. All right. We are going to go into the courtroom right now to hear that apology, as well as the sentence for this ex-deputy Leslie Bolio.
The sentencing for Leslie Boileau is underway. He's the former sheriff's deputy who shot his girlfriend, Paulina Wright. You remember that case here on Court TV? He faces up to 30 years in prison after a jury convicted him of manslaughter. Before we go into the courtroom, here's a look back at some of the moments from his trial.
I need help. I need medics right now. No, no!
Is this the house of a 1037 or is he just here?
That's a deputy.
Okay.
We were around with the guns. I was cleaning them. She's like, you need to teach me. You need to teach me.
When the gun went off, it was in your hands.
It was.
And when the gun went off, you were the one who intended to pull the trigger at that point.
Yes.
Is she breathing? Is she awake?
No, she's medic. She's shot in the head. Damn it!
Are you a deputy?
Were you looking at Paulina when you were doing that?
No, I was looking at the TV.
What we did prove throughout yesterday is that the defendant intentionally committed actions that led to the death of Paulina.
I didn't want to do this. I know better.
The defendant is guilty of manslaughter, so say we all day this first day of October 2025.
All right, remember his defense was that he was helping her learn how to clean a gun and use a gun, but it was like that big AR thing, and she was naked during this training session. She ended up dead. He was convicted. Now it's sentencing time. Here is Paulina's brother giving his victim impact statement.
How you spell it?
Gregory Wright, Grigory-WRIGHT.
What would you like to tell me, sir? What would you like to tell me?
My name is Gregory Wright, and Paulina was my sister. Me, Paulina, and Julia were all born in Russia, and we got adopted in 2004. For the first 5 years of their life, their safety was on me. We didn't have a good father figure around, so I was in charge of keeping them safe. And I did until we got to America, and then it was on my father. And he did great for 13 years. And then the responsibility shifted to Mr. Boileau, and he was not able to do that. I saw Julia get married. I saw her become a mother. It breaks my heart that I won't get to see the same for Paulina. I have a daughter, 8 years old. Paulina won't get to see her grow up, graduate high school, any of that. For the rest of my life, I will have to console my father and my mother and my brother and my 3 sisters. Words do no justice in describing how much I miss her. And how much this hurt me. That is all, Your Honor.
Patty, any questions?
No, sir.
You all mind if I ask a question or two?
Sure. I do not.
You're her older brother?
Yes, sir.
How old are you?
I am 29 years old.
What's her birthday?
Her birthday is December 31st, 1998.
When did she come to the United States? When did you all come to the United States?
November 16, 2004.
Very good. Thank you, sir.
Yes, sir.
Your Honor, next state would call Julia Dawson to the stand.
Now, you raise your right hand. You swear affirming testimony you give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, you can put your hand down. Tell me your name and how you spell it.
Julia, Julia, Dawson, DAWSON.
What would you like to tell me?
My name is Julia Dawson. I am Paulina's twin sister. Growing up, our grandpa called Paulina Dimples and I Giggles. We were Dimple and Giggles. Since Dimples has gone, my giggles seem to have disappeared. Rarely are they heard much these days. Losing my twin sister in such a horrendous act has devastated many, but destroyed me. There are no words I could ever say to describe the pain and heartbreak I am feeling. I have lived 25 years being a twin to Paulina. Paulina and I had a bond no one could or would ever understand. God blessed me with one twin. There is no going to find another. Paulina is all I've known my whole life. The bond formed between us even before birth is a lifelong connection. And in a blink of an eye, that was all taken away from me. Half of me has died. I desperately pray I can feel whole again, but knowing Paulina is no longer here or side with me leaves me numb. Paulina was my biggest cheerleader. She stood next to me on my wedding day, held my hand during the birth of my daughter, pushed me to do hard things, encouraged me to step out of my comfort zone, showed up for me, listened to me, cried with me, laughed with me. I could keep going. I would no longer get to make any memories with her. I just cling on to the 25 years God blessed me with having her by my side. She was my best friend. No morning as I wake or lay my head down to rest go without tears, anger, pain, and Paulina on my mind. I'm dreading the day I have to tell my daughter and future kids the horror story of what happened to their Aunt Polly. All I have left is photos and memories to share. My daughter will never get to experience the love her Aunt Polly would have continued to give her. She was the best aunt. Anytime she saw her niece and nephew, her smile would light up the whole room. Paulina only got 8 months with her babies before she was taken. The good days are stolen from me because I remember Paulina isn't here to celebrate and do life with me. The bad days are only worse because I'm constantly reminded of the evil way she was taken for no reason. I am now left to celebrate birthdays on my own. I am left to blow out Paulina's side of the candles on our birthday cake. A day that's supposed to be filled with life and celebration is now a day I mourn and wish to never celebrate again. My life is now filled with fear, anger, anxiety, sleepless nights, nightmares, endless tears and heartbreak that will never go away. Through my tears, pain, and sorrow, Jesus is better. I do not know why this happened to Paulina. I do not know why this happened to both families. But I do know we have a faithful, all-knowing, and loving Father. Because of Jesus' blood, Paulina is in eternal glory now, where we all yearn to be. That is all I have left to cling on to. I will see her beautiful face again, and what a celebration that will be. My life will live on, but it will never be the same again. The emotional wounds caused will never heal. I will continue to carry Paulina's memory on.
Thank you, ma'am. Any questions?
No, sir.
You can be seated, ma'am.
State has no more witnesses, Your Honor.
Mr. Daddy, do you have any witnesses you wish to call?
Yes, sir. Juan Ferran.
Dave Williams. Let's switch it.
Have you raise your right hand? Do you swear affirm any testimony you give will be the truth, the whole truth, nothing but the truth? So you got. Yes, sir. All right. Tell me your name and how you spell it.
David Boyle, DAVID-BOILEAU.
Great, thank you, sir. Mr. Patty.
He has a letter that was submitted with the other letters. You're welcome to read that, or if you want to add to it, you can do that now.
I have read it.
You have read it?
I have read it, but if you want to read it, you can. If there's anything you want to say, you can.
If you've already read it, sir, then I'll just add to it. My condolences to the Wright family. It's a terrible tragedy that happened. That's all I can say.
Thank you.
Thank you, sir. Next.
And I would like to take some brief testimony from Mr. Boyle.
Okay. All right. Let me have you raise your right hand, sir. You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
You put your hand down.
Would you state your full name, please?
Leslie Dale Boyle, Jr.
All right. Mr. Boyle, at the time of your arrest, you were employed as a Marion County deputy, is that correct?
Correct.
How long had you worked for the sheriff's office?
8 years.
Have you ever been convicted of a crime?
No.
Have you ever been arrested for a crime?
No.
Is there anything else? I mean, you testified at the trial. Is there anything else that you would like to say today?
Yeah. I've gone over and over in my head about how blind I could have been to allow this situation to unfold. Comes down to me being complacent, prideful, arrogant, and overconfident. And I know I can't make up for what happened that night, but I'm gonna do my best to make a difference. And I'm truly sorry to both families.
State, did you all have any questions?
No, Your Honor.
Was there any other evidence you wanted to present?
No, sir.
All right. Oof, that's rough. This whole thing is rough. Twin sister, losing her twin. Anton Bell's with us. He's a prosecutor in Hampton. Man, you listen to the victim impact statements are the worst. And this was not a, no one is alleging that he went home and he was mad and he shot her. This was an accidental shooting, and it was, as he said, you know, he let his guard down. He should have known better. What's your take here? What should the judge do in terms, you know, he's got no priors, in terms of the top and the bottom and the middle? What is your overall feelings on this case, Anton?
So, good morning, first of all, Tim. So, when I look at the evidence that was presented in the trial, followed this case, I recognize that the state decided to charge him with manslaughter. But Tim, in reality, there was enough evidence potentially to have maybe charged him with murder. Because think about this. You have an individual who is a law enforcement officer who has been a law enforcement officer for quite a number of years. He is trained every year on gun safety because he has to be certified in order to be able to use his weapon. In addition to that, you have a young lady who, when she was discovered, she was naked and her body had been moved. So the crime scene had been shifted in some way. And everything we have concerning what occurred, for the most part, outside of the forensics, is based on his version of the events. But when you look at his version of the events, there's some questions as to that. At least I have some. First of all, she's shot in the forehead, a direct fatal shot for most people. Secondly, her finger was shot before she was shot in the head. Now, think about that. Put your hand up to your forehead. The average person's hand is not in this position. So that lets me believe that, or leads me to believe that that particular shot, we call it a defensive injury. So she saw this coming. And the fact that she wanted to, according to him, wanted to learn how to use a firearm while she's naked, and then she's putting her hand up in front of her forehead, and he's shooting her with one direct shot to the forehead because he's trained to use that firearm in such a manner. It leads me to believe that it was more intentional than he's letting on. And as a result of that, that judge is going to look at that.
Yeah, I mean, I think you speak for a lot of people that watched that trial. There were his didn't add up. So we'll see. We'll get a break when we come back. The judge's sentencing. What's he going to do with Leslie Boileau? And soon, closing arguments in the adopted son murder trial for Dima Tower. Right now, the judge going over those jury instructions. We'll head into that Florida courtroom when the arguments begin.
Mama tried. Now my daddy's crying because I'm in here.
You are the common Sheriff's Deputy Leslie Boileau. He was convicted of manslaughter and the shooting death of his girlfriend, Paulina Wright. He faces a top sentence of 30 years in prison in the state of Florida for manslaughter. We've heard from both sides, heard from the defendant. Now it is time for the judge to speak and impose a sentence. Let's go in.
Mr. Boileau, the maximum sentence you could receive for this offense is 30 years of imprisonment. The Criminal Punishment Code would have me sentence you to a term of imprisonment of at least 12.125 years. You have asked me to consider imposing a downward departure sentence of less than that. I do find that the greater weight of the evidence has established that this was an isolated incident committed in an unsophisticated manner for which you have shown remorse. As such, a sentence of less than 12.125 years could be lawfully imposed. But simply because a downward departure sentence can be imposed does not mean that it must be imposed. The question before me today then is, should I depart? To make this decision, I must weigh the totality of the circumstances of this case, including the aggravating and mitigating factors. To that end, I have thought about the evidence presented and reflected on what justice requires here today. On the one hand, you were a law enforcement officer. You swore an oath to serve as a law enforcement officer, a solemn promise to protect others, even at the risk of your own life. And for 8 years, you did that. And by all measures, you did that well and honorably. You know what it's like to put on a bulletproof vest each morning, knowing that your day may bring you face to face with mortal danger at the hands of a person who may seek to use a firearm to end your life. Most people don't know what that's like. Your service will be recognized today as a mitigating factor, as will your record of good character and the good that you did in this community until September 19th of 2024. But one cannot simply ignore the other side of that coin. You, more than most, understood the power of a firearm and the responsibility that comes with holding one. Putting on your vest every day was also a reminder that firearms are deadly weapons capable of ending life. You were trained. I've looked through your training records. They were admitted into evidence during the trial. You were highly trained how to handle firearms safely, to protect innocent life, and to avoid taking it. Your training records speak for themselves. Treat every weapon as if it were loaded. You knew all of that, and you knew to never point your weapon at anything you did not intend to shoot. But despite all of that, on September 19th, 2024, you pointed a rifle at Ms. Wright, pulled the trigger, shot her between the eyes, and killed her. Afterward, you had what appeared to be the audacity to cast blame upon her because she asked you to teach her how to use firearms. She was innocent. It never should have happened. I could say that it could have been prevented, but that would imply it was simply an accident. It was more than that. It was senseless, reckless, and criminal. There will be no winners in the courtroom today. You have brought loss to everybody here, and none of their lives will ever be the same. Paulina Wright lost her life in the promise of all that it could have been. Her family very clearly lost a lifetime of memories they will never get to make. And even your family, they have to live with having lost having you in their lives in the way that they deserve. And your actions and your choices are to blame for all of that. Mr. Boileau, you are going to lose your freedom today. The totality of the circumstances in this case do not warrant a downward departure sentence, and I will not exercise my discretion to impose one. I will, however, try to achieve some measure of justice here, with an understanding that true justice would be restoring what was lost, something that is far above what I have the power to do. Every life has worth beyond measure, and every act has a consequence. Your act of taking Ms. Wright's life in the Judge. The blue man flashed. Should be good. Madam Clerk, if you would mind calling ECR. Every life has worth beyond measure, and every act has a consequence. Your act of taking Ms. Wright's life in the manner you did is no exception. It is a crime, and for it you will be punished. Accordingly, as to the offense of manslaughter with a firearm, you will be adjudicated guilty. You will be sentenced to 25 years, 8 months, and 20 days in the Department of Corrections. You will receive credit for 47 days served. I've calculated that as follows. You were arrested on September 20th, 2024, and posted bond on September 21st, 2024. That is 2 days of credit. You were remanded into custody following the trial October 1st, 2025, and remained in custody through today. That's 31 days in October, 14 thus far in November, for a total of 45 days. It's a total of 47. You'll pay a fine, $1,000. Any mandatory court costs and surcharges of $100, and the cost of prosecution to the Office of the State Attorney. You have 30 days if you'd like to file a notice of appeal, and if you cannot afford to hire an attorney to represent you on appeal and qualify, I am happy to appoint the Office of the Public Defender to represent you on appeal. That'll be the sentence of the court. Would you like me to consider, Mr. Taddy, appointing the Office of the Public Defender for appeal?
Not this time.
Okay, very good. Court will be adjourned.
Whoa, book thrown at Mr. Boileau. 25 years, the max was 30. The recommendation with his record 12-5, he wanted a downward from 12-5, not happening. Boy, you were right, Anton Bell. The judge saw right through his story. Had he called 911 and said, we like to play, I like to play weird sex games with guns, and we drank 4 margaritas, I'm sorry this happened, would it have made a difference? Because he not only lied, and the judge did say, you blame the victim here.
Mm-hmm. I don't think it would have made a difference. And the reason I don't think it would have made a difference is because I think that judge believed that he got a gift. And that is that he was charged with manslaughter instead of murder. Again, that the facts just don't add up. I truly believe, based upon the way the facts rolled out in trial, there's a highly suspicion that it could have been more than what we know, and that it could have been more intentional than what we know. And based on some of the comments that, as you and I have both heard from others, the public is thinking there's more to this story. Who plays with a firearm when they're naked? And again, that defensive hand, I just can't get that part out of my mind. That defensive injury to the forehead, to the hand right here. Who does that? No one does that in an ordinary common act. So I believe the judge saw through that, and I believe because, as the judge mentioned, you are trained never, ever to point a firearm at anything unless you are prepared to shoot it. So the fact that you pointed the firearm at her, no matter whether you forgot to unload it or not, you were prepared to shoot.
Yeah, I think the judge agrees with you and others that there was more to the story. And yeah, the defensive, which she knew the moment before she died that she was potentially going to die, and whether she had a feeling that if it was a weird game that they were playing, people do weird things, let's face it. And, you know, this is a mess around and find out scenario. This is at its low end, and it's something more sinister at the other end, and the judge definitely agrees with you, Anton, that something was awry with his version of events. It didn't add up, and now he's going to do 25 years.
So former Deputy Leslie Bolio, I pronounced his name wrong earlier, I apologize for that. Leslie Bolio will serve 25 years in prison for the murder of his girlfriend, and I say it's appropriate. So the sheriff's deputy offered apology, calling himself complacent, prideful, and arrogant before learning his fate. Yep, I agree with that statement. He thought he was going to get a downward departure, but the judge saw right through all that and said, downward departure, forget about it. 25 years. Once again, that's justice served. And we got another crazy case. Brian Walsh is set to stand trial for his wife's murder. He has been found mentally competent, and then he will stand the charges of the murder of his wife. Let's get ready and go take a look at how that breaks down.
You're watching Court TV. I'm Kelly Craft in today for Ted Rowlands. Thank you for being with us. We're going to turn now to Massachusetts, where Brian Walsh is back in court today for a competency hearing. Walsh was set to go to trial for the murder of his wife last month, but his trial was delayed after a judge ordered Walsh to undergo a mental health evaluation. Prosecutors allege Walsh murdered and dismembered his wife, Anna, on New Year's Day in 2023. Her body has never been found. Before we get you back into the courtroom there or into court, here's Court TV crime and justice correspondent Matt Johnson with more on this case against Brian Walsh.
No comment from Brian Walsh after he was charged with the murder of his wife, Anna Walsh, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walsh was last seen here at her Cohasset home on New Year's Day. Anna was last seen at home between 4 and 5 a.m. by a family member. Walsh told police that he had slept in that morning, but prosecutors say that he was actually awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell.
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., Cap saw best tool to dismember. At 1:10 p.m., can you be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walsh came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes.
On January 3rd, prosecutors say Walsh drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walsh drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. Then on January 6th and 7th, police searched the Walsh property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walsh was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walsh, as well as disinterring of a body.
Let's go into court now for the start of that hearing.
Welcome, as I said, to counsel, and welcome to Mr. Walsh. I have a few things on my agenda. The first one, which is over here, is the competency. I've now received a report from Bridgewater State Hospital, a comprehensive report from Dr. Ryan. And in that report, Dr. Ryan concludes that the defendant is competent and ready to stand trial. And with that finding, which I accept, I had a brief conversation with the side of the bench. What's the defense's position? I just want it on the record, on the public record, with regard to the defendant's competency.
Two things here. One, we're not contesting the competency finding. Two, we've had conferences with Dr. Ryan. We had them last night. What he asked us to do, is he is concerned that changing the letter to the jail may have an adverse effect on this report. And he wants us to guide us, ask us to inform the court if he's concerned about that. He said that's not his lane, but we want to let the court know that we have those concerns, and we'll bring it to the court's attention as soon as we think they might be posed a problem. And we're also informing each other. Other than that, we're not contesting.
All right. As with any case, and any time, in my experience, the defendant goes to Bridgewater and then is returned to the facility, there's always a transition period. He's been there for 40 days now and has gotten, as I understand, into a routine. And that routine is going to be changed as he moves back to the House of Correction. So understandably, there will be some transition period, and you and alerting the facility knows this, they deal with this quite regularly. But I understand your intent to alert me to it, and we'll have some time here, I believe, between the time that we're picking a jury in this case and the time. I'm not suggesting that you're not working at that time, but the defendant's role in that is significantly different than it is when we're actually actively engaged in the trial. So hopefully that'll give him a nice time to settle back into the House of Correction. But obviously, if at any point you become concerned about that, I know you won't hesitate to raise it with me.
Thank you.
All right. So, let me, and I discussed this with you at this side of the bench as well. I received some edits from the defense to the questionnaire which I will incorporate into the next version of the draft questionnaire. It's always a draft until the minute that I finalize it and send it to that pool of jurors. Speaking of that pool of jurors, somewhere on my desk, I have the updated numbers. Who knows what the yield will be, but I expect to take about 70, if I can, 60 to 70 jurors a day. In my experience, it's hard with the questionnaire, even without doing all the copying, to get through more than that number in a day. And there are other cases that are starting on Tuesday. And so if we can accommodate those, we will. We'll have to see what the draw is. The expected number is 105 now for Monday, and we're going to hold those over to Tuesday because, as you know, we're doing the final trial conference on Monday, and then we'll start the impanelment on Tuesday. So it looks like 105, 126, 121, 68 on Thursday, but those people will be pushed and held over till Friday. So we'll have a full group of some number of people to work with in getting a jury next week. And then jurors are here also on Monday and Tuesday of the following week. And I think we're the only game in town. That is, I don't think anybody else is paneling on Monday and Tuesday. Our intent is, if we get a jury during that allotted time, we will start the trial, the substance of the trial, on 12/1, the Monday after the Thanksgiving holiday.
All right, we are watching that competency hearing that's taking place in Massachusetts. We are gearing up for this trial. This is going to be Court TV's next biggest trial that we're going to cover here. What the judge is deciding right now is if Brian Walsh is fit to go to trial for murdering his wife. Let's go ahead and bring in criminal defense attorney Michael Gottlieb to talk about what we were hearing there. This is a competency hearing, Michael. Kind of talk about why that's taking place in the first place.
So a defendant cannot be brought to trial unless a defendant is competent to proceed, meaning they have to understand the roles of all the actors, the judge, what the judge's role is, what the prosecutor's role is, what the defense attorney's role is. They have to have an ability to assist, to behave in court, to testify relevantly, and it seems like he was sent away for evaluation. He was gone for 40 days. The judge has made a determination based on the report that he is competent, and it doesn't sound like the defense team took issue with that, only they wanted him to get reacclimated to the new prison setting that he is in. And now the judge is setting the trial schedule.
In regards to jurors, so jury selection is going to begin next week. From a defense counsel's standpoint, Michael, who would you be looking for to sit on the jury?
So, you know, that's an interesting question. When we pick juries, we play amateur psychologist in terms of trying to figure out who's going to be the right person to be selected. I wouldn't want anybody who's been divorced. This is a situation where, you know, obviously there was some kind of strife. They found evidence of the murder in the house. They found him doing things. There's circumstantial evidence. So you're going to want people perhaps that are very analytical, who are going to want more than circumstantial evidence, people who haven't been in a bad relationship, people who are going to want strong scientific evidence, DNA, blood evidence, maybe stronger than what the government seems to have in a case like this. But it's always very difficult to know where people are going to land. Very hard to pick juries and decide who you want before you have the opportunity to speak with them and really know what they bring to the table.
Yeah. Good point there. Yeah, the jury selection is going to begin next week. I believe she said she's going to start bringing in 60 to 70 people. So, of course, we're going to follow that and bring our viewers up to date on all the developments in that case that will be taking place in Massachusetts. Michael, thank you. We're going to squeeze in a quick break, getting close to 12 o'clock. But you can see we have two jury clocks up right now, one in Truesdell that's taking place in Cedar Rapids, Iowa, the other in the Florida v. Tower case. We'll squeeze in a break. We'll be right back.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge watching Bull, Sundays on Court TV.
Back now to Massachusetts, where Brian Walsh has just been cleared to go forward with his murder trial. Walsh is charged with first-degree murder in the presumed death of his wife, Anna, who was last seen on January 1st of 2023. The trial was initially delayed after a judge ordered Walsh to undergo a mental health evaluation, but he has now been cleared. Let's go in now for more of that hearing.
Thanksgiving holiday. Everybody on board with that schedule? All right, good. Let me next address, and then once I do this, I'll certainly turn it over to you. We're going to have our formal, really today's purpose was to address the competency, but to the extent that I could pick off issues that aren't technically motions in limine, but other important motions to the parties, I focused on those today. And I am prepared now to make a ruling on the change of venue paper. That's paper number 219, and I'm going to read that into the record now. Mr. Walsh has moved for a change of venue on the grounds of extensive and prejudicial pretrial publicity that he asserts has tainted the jury pool so as to deprive him of his right to a fair trial by impartial jury. Alternatively, the defendant seeks an order that prospective jurors be selected from outside of Norfolk County. In support of his motion, the defendant has submitted evidence of extensive national and local media coverage of the case, beginning on January 6, 2023, after Anna Walsh was reported missing, and continuing till the present day, as well as evidence of social media engagement with this case. After careful consideration of the defendant's motion and the exhibits provided to the court, I'm denying the motion and the request for alternate relief for the following reasons. The court may order a change of venue where there exists, quote, it exists in the community where there is a prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial. And that cites back to Massachusetts Rule of Criminal Procedure 37 and Commonwealth versus Clark, 432 Mass 1 at 6, a 2000 case. A judge has substantial discretion to transfer a case to another county based on pretrial publicity. And according to Commonwealth versus Gaynor, 443 Mass at 245 at 259, pretrial publicity, even even pervasive adverse publicity does not inevitably lead to an unfair trial. A change in the place of a trial should be ordered with caution and only after the defendant has established, based on a, quote, solid foundation of fact, that the pretrial publicity has created presumptive prejudice. And to that I cite to Commonwealth versus Hart, 493 Mass 130 at 141, and Commonwealth versus Tulin, 460 Mass at 452, pinpoint site 462, 463, a 2011 case. Presumptive prejudice exists only in truly extraordinary circumstances where the trial atmosphere is utterly corrupted by media coverage and, quote, the entire venire may be presumed prejudiced regardless of specific voir dire procedures utilized. This standard is only met if the publicity is both extensive and sensational. And to that I cite to Commonwealth versus Who's, 467 Mass 395, 406, a 2014 case. In assessing whether pretrial publicity precludes a fair trial, The court should consider additional factors such as, quote, the size of the community, the length of time between the peak media coverage and the date of the trial, and whether the news stories contained a confession or smoking gun rather than merely being unkind.
Brian Walsh competent to stand trial, but the jury selection will begin next week. Brian Walsh is charged with the murder of his wife, facing several charges, in fact, including first-degree murder in the death of his wife, Anna, who disappeared in January 2023. His trial was initially scheduled to begin in October, but it was delayed when he was admitted to Bridgewater State Hospital because of competency concerns. At the competency hearing on Friday, Judge Diane Frenier stated that she had received a report from the hospital which concluded that Walsh was competent. She ruled him competent and said the trial would proceed with jury selection beginning Tuesday, November 18. Frenier also took the opportunity to deny the defense motion for a change of venue. Although the media coverage has been extensive, Frenier said it has also been quite factual. Frenier says she anticipates the trial will begin with opening statements and testimony at the earliest December 1st. All right, so we're going to go to now. The next case on our docket is the sentencing of Dakota Patton in the Machete murder plot trial. All right. Let's see. All right. Let's go to that sentencing right now.
I know Melody would want me to forgive you, but I'm not sure that will ever happen. And if it does, it's only for her and not you. You've taken so much from me, my family, friends, and even complete strangers that never had the chance to meet her. Melody will live on forever in each and every one of us. She will be remembered for the kind, caring, loving, organized, silly, artistic, music-loving, slime-making, selfie-taking, video-making, supper-cooking, animal-loving girl we all remember. I don't believe for 1 minute that McKinley made you do it, or that you made him do it. I believe that you're both 100% guilty of murdering Melody, our daughter, and their loved one. You're both cowards. Neither one of you had the balls to stand up to each other and do the right thing. I also know that you two are the most naive, stupidest criminals that ever walked this planet. Leaving all of her belongings in the trunk of the car, linking your phone to hers, having her password, her deceased sister's birthday, in your phone, and being seen together on surveillance videos before and after the crime. Let's talk about your selfies for a minute. What are you, in middle school? At the beginning of the night of February 17th, your subjects didn't include any classes. And then, all of a sudden, you had classes. You took more than 200 selfies. 200. With them on. Did you see them as a trophy or a souvenir? I don't. I see them as the evidence that put you away for the rest of your life. By the way, thanks for taking them home with you. You made the job a little easier for everyone seeking justice for Melody. Maybe now you can get your own state-issued, non-working classes. I've been called a helicopter mom a few times now, and I take that as a compliment. Being a loving, caring, concerned, supportive, devoted mother to Melody is an honor. I am proud to say this helicopter mom got my daughter's murderers put behind bars in days, instead of weeks, months, or years. You fucked with the wrong mama. You messed with the wrong family. I'm sorry you never felt love. Anybody capable of doing the things you did could never fit into a loving, caring, supportive family. I'm sorry you never experienced a family with such strong characteristics. In fact, I don't see any of your relatives here supporting you today. Maybe the issue's you and not the rest of us. I'm relieved to know that there will never be another innocent victim with your name attached to them. If you would have let Melody get to know you, she would have given you the shirt off of her back. Instead, you took it, and so much more. I want you to think about her during every disgusting cold meal you eat. Every time you lie down on that cold-colored bed. Every time you wake up to the concrete walls and iron bars. Every birthday, holiday that you don't get to celebrate. Every time you have to ask to use the restroom. Every time you step out of line. Every time you have a nightmare. Melody is providing for you. She will forever provide those bars that obstruct your view for the rest of your life. And I hope she haunts you forever. Justice will be served to those who deserve it, to its fullest extent here on earth. A much higher power will get the final justice. I have no doubt when your time comes, you will not be allowed in the same place we all know Melody is now, with her sister Ellie, safe and far away from everything evil like you and McKinley. I will fight every day of my life to keep her memory strong and let her live on as long as I can. I know I'm not the only one determined to do this. So, from all of her loved ones, we all wish you the life that you deserve until you take your last breath.
It makes a little difference since the sentence is mandatory, but the state did make mention of me hearing the evidence in both this case and the McKinley-Louisiana case, and I just want to state the record that my sentences that are going to be issued here today are based only on the evidence received in this case and have nothing to do with the evidence heard in another case. The sentence in this case for murder first and murder that is appropriate for these violent, incredibly cruel, and completely senseless acts. Your offense cuts the young life short and deprived Melody Hoffman's family and friends from having her in their lives, which is understandably devastating to them, but also undercuts the safety and feelings of security in the community. A sentence of life in prison with no possibility of parole is the appropriate sentence for these crimes as necessary for the protection of the community. The maximum sentence for the offense of conspiracy to commit a forcible felony is a 10-year indeterminate prison term. While it is largely symbolic in this case, given the sentence of life in prison for the other offenses, the court does find that the maximum sentence of 10 years in prison is the appropriate sentence based on the level of planning involved and the fact that the forcible felony involved is Class A felony. So at this time, the court adjudicates the defendant to be guilty of the offense of murder in the first degree in violation of Iowa Code Section 707.1 and 707.21b. As a sanction for this offense, the defendant is committed to the custody of the director of the Iowa Department of Corrections for the rest of his life. The court further adjudicates the defendant to be guilty of the offense of kidnapping in the first degree in violation of Iowa Code Sections 710.1 and 710.2. As a sanction for this offense, the defendant is committed to the custody of the director of the Iowa Department of Corrections for the rest of his life. As to each of these offenses, the defendant shall not be released on parole unless the governor later commutes the sentence to a term of years. The court further adjudicates the defendant to be guilty of the offense of conspiracy to commit a forcible felony in violation of Iowa Code Sections 706.1 sub B and 706.3 sub 1. As a sanction for this offense, the defendant is committed to the custody of the director of the Iowa Department of Corrections for an indeterminate term not to exceed 10 years in order to pay a binding amount of $1,370. The defendant is given credit for qualifying time previously served on this offense. The term of incarceration as to this offense only may be reduced because of good time, work credits, and program credits, and the defendant may be eligible for parole before the sentence is discharged. While largely symbolic, count 1 and count 2 will run consecutive to each other. The reason for the consecutive sentences is that the kidnapping included separate planning and represented an entirely separate cruelty to Melody Kaufman, as she was picked up with no idea what was coming, with all the panic and separate torture associated with being taken, confined, and moved, all of which occurred before the separate act of murdering her. The court finds that because of that, and based on all the facts and circumstances of the two offenses, that they should run consecutive to each other. The sentence in count 3 will run concurrent to counts 1 and 2. Temporary custody is placed with the sheriff and then transferred to the DOC. Pursuant to Iowa Code Section 910.3b, defendant shall pay restitution in the amount of $150,000 to Melody Hoffman's heirs of law. Now, certain defendants are presumed under the law to have the ability to pay what we call category B restitution, but defendants have the right to request a determination of the reasonable ability to pay. Mr. Petrova, is your client intending to file an application for determination of category B restitution?
Yes, Your Honor, we did file one with this case.
I've not had a chance to review that. As the state had any objection to the court reviewing that application and making the determination, basically we can file it. And so, sir, what that means is that I'll either grant that request and find that you do not have the ability to pay, which is what I expect will occur. If for any reason I would determine that you did have the ability to pay, I would reset this for hearing so that you have a chance to be heard on that. Defendant shall submit a physical specimen for DNA profiling pursuant to Section 81.2, 901.5, 8A, sub A. Defendant's prior bail provisions are exonerated. No appeal bond is set. In determining the sentence, I considered defendant's age and circumstances, the nature and circumstances of each offense, and the fact that the sentences for murder first and kidnapping first are mandatory under Iowa law. Finding the sentences will offer the defendant maximum opportunity for rehabilitation and provide for the protection of the community. Now, Mr. Van Patten, you have the right to appeal this case to the Iowa Supreme Court. If you're unable to pay the cost of an appeal, You have the right to apply to the court for appointment of counsel and for furnishing a transcript of the proceedings. All is provided in Iowa Code Chapter 814. In order to perfect an appeal, you must file a notice of appeal with the clerk of court here in Manhattan within 30 days of today's date. This is a jurisdictional requirement, which means that if you do not file a notice of appeal within 30 days, you would be forever denied the right to appeal. Likewise, failure to comply with other provisions of Iowa Code Chapter 814 could preclude you from pursuing your appeal. If you do appeal, you must cause to be served on and delivered to the Iowa Attorney General a copy of the notice of appeal. Is there anything that the state police have missed there? No, Your Honor. The defense?
No, Your Honor.
All right, order.
Okay. Dakota Van Patten. Sentenced to life without parole for the kidnapping and killing of 20-year-old Melody Hoffman. He was found guilty in September of first-degree murder, first-degree kidnapping, and conspiracy to commit a forcible felony for his role in what prosecutors described as premeditated machete murder plot. Judge Chad Kepros denied the defense's motions for a new trial, ruling that the jury's verdicts were fully supported by substantial evidence, including Van Patten's DNA on duct tape and a knife, incriminating photos after the killing, and testimony showing that he and co-defendant McKinley Luzma acted together at every stage. So Dakota Van Patten will be spending the rest of his life behind bars without the possibility of parole. Oh, justice served. Let's see what else we got left on the docket tonight on Saturday night's main event. I got two stories left. First, a confessed hitman. A confessed hitman is changing his story about a Microsoft executive's murder for hire plot. Now, we're not going to go through an entire episode of Vinnie Politan Investigates as much as I would like to do that. No, I'm not. No, we're not going to. Here's the breakdown of what's going on in that. We're in Jacksonville, Florida. New filings ahead of a murder trial show the confessed hitman at the center of a murder for hire plot has threatened to change his testimony. Microsoft executive Jared Britigan, aged 33, was shot and killed on February 16, 2022, after getting out of his vehicle to remove a tire from the road. At the time, Britigan was driving home with his 2-year-old daughter after dropping his 9-year-old twins off with their mother. Investigators determined Britigan was the victim of a murder for hire, which was allegedly masterminded by his ex-wife, Shauna Gardner, and her current husband, Mario Fernandez Saldana. Henry Tenon, the man who allegedly pulled the trigger, was the first to be arrested. Prosecutors said he pleaded guilty and agreed to testify that he was hired by Fernandez to commit the murder. But at a hearing on January 13, 2025, Tenon suddenly changed his story, telling the court that he had previously given false testimony in his sworn statement accusing Fernandez. In an interview the next day, January 14th, Tenon spoke with prosecutors and told them that Tenon said he told the state about Fernandez so that the state would interview Fernandez and learn that Tenon was not guilty. The prosecutor told Tenon that it did not make sense for Tenon to confess to a crime he did not commit in order to prove he did not commit the crime. After speaking with prosecutors, Tenon admitted that he had told the truth in his sworn statement, but now he was second-guessing his decision to cooperate, believing he would be serving a life sentence either way. He repeatedly denied that anyone was asking him to change his statement or had threatened him. Ultimately, Tennant told prosecutors that what he had said in his initial sworn statement implicating Fernandez was true. Both Fernandez and Gardner face a potential death sentence if they are convicted of murdering Britigan. This is it's already looking tough right now, and honestly, I don't like Gardner's or Fernandez's chances, and given the fact that Tennant is changing his statement, make their chances a lot worse. So, good luck, you two. You're really gonna need it. And finally, a man murders two others inside a Michigan dealership over a $3,000 car dispute. Maybe we'll get some more information via Court TV. In fact, what we're going to do is go to a press conference regarding this. But I'll give you a small bit of details from here first. Police say the double homicide at a Shelby Township auto dealership stemmed from buyer's remorse over a $3,000 Hummer. Terrence Sandals, on the right, you see on the right side of your screen, was arraigned on November 10th on 15 felony charges. 15 felony charges, including first-degree murder and armed robbery in connection with the killings. Two of the charges were later withdrawn. The fatal shootings happened on November 7th at Star Auto Sales on Ryan Road near Auburn Road, where Sandals allegedly killed dealership owner Marvin Batu and customer Gaith Babin. So what we're going to do right now is, as I said, we are going to go to this press conference and we are going to get all the information regarding this case.
Good morning, everyone, and welcome to Shelby Township. Thank you for coming on this solemn occasion. We're going to go over the facts of a double homicide that occurred on Friday, November 7th. Our police officers were dispatched on Friday, November 7th at 12:38 p.m. to Star Auto Sales. It's located at 47092 Ryan Road for a welfare check. An employee who was out buying parts at the time came back into the office and observed his boss and another male down in the office with gunshot wounds. At this point, I'd like to introduce my team. Although Mr. Lucido is a Macomb County prosecutor, he's been an integral part of this investigation, and so is his prosecutors. I'm sorry, he's over here. My deputy chief, Jason Schmiller, runs operations. Lieutenant Brandon Dowdy. Brandon is their detective commander, and he also is their SWAT team commander, which is called our Tactical Response Unit. Tommy Gibbs is the officer in charge of the homicide investigation, and then Jason Armstrong is our team leader for our Tactical Response Unit. which was critical. Over here to my right is Mr. Ron Robinson. He's our state rep for the area. Mr. John Vermeulen, one of our trustees. Our officers arrived on scene at 12:41 p.m., and we discovered 2 males, both deceased from gunshot wounds. They were in the office of Star Auto Sales. The victims have been identified as Gaith Babone. He's a 48-year-old male from Clinton Township. His picture is going to be put up on the board for you. And then the owner of the business, Marvin Batu. He's a 40-year-old male from Shelby Township. He was also the owner of the business. Marvin is a married father with 3 young children under the age of 5 years old. And I apologize, Gaith also was married with children. I just don't know how many children that Gaith had. Our officers immediately deployed our canine, our drones, detectives, our evidence technicians immediately and began investigating. We discovered 5 9mm shell casings that were located inside of the office. Surveillance video from inside of the business showed the suspect entering the business and shooting both Baban and Batu from point-blank range. Video showed that the suspect was a black male wearing black clothing and wearing a mask to hide his identity. Video also showed the suspect exiting the store and leaving the business on foot. He walked away very coolly. I think some of you might have seen the video already. That was released not by us, but by, I think it was a local business. Through our detectives' interviews, we learned that a black male had been in the business approximately 3 weeks ago, arguing and making threats to the owner regarding the sale of a vehicle. It was a Hummer vehicle. It was purchased for, I think, $3,000. Closed-circuit TV review and our flock camera system, which has done an incredible job for us, determined a potential getaway vehicle. The vehicle was determined to be a rental vehicle. What's the name of the rental? Turo. I never heard of it before. They had to teach me about it. So my understanding is this, I want to explain this for a second, how complicated this became. So when we identified what we thought was the suspect's getaway vehicle, when we run the registered, our flat cameras and surveillance video picked up the license plate. It comes back registered to a guy. So we thought this was the guy. Well, it turns out that his name has 100 vehicles registered to him. So thankfully, when we called him, he answered the phone, and he explained this is a Turo vehicle, and here's who we rented the car to. And who he rented the car to was the man that had the trouble with the Hummer a few weeks earlier. We immediately locked in on the suspect. At that point, our detectives, led by Brandon Dowdy, identified Terrence Jermaine Sandals. He's 46 years old, and he's from Houston, Texas area. At that point, we contacted Mr. Lucido's office and obtained a search warrant for the vehicle and for the location where we identified him. And how we identified him was through another search warrant on his phone. Our Special Investigations Unit, which I'm extremely proud of, was able to locate the suspect's vehicle at a hotel room in Romulus. At that point, we immediately set up surveillance on the vehicle while we obtained our search warrants for evidence from the hotel room. Surveillance video from the hotel showed the suspect entering the hotel approximately 1 hour after the murders. He was wearing the same clothing and shoes as we saw on the surveillance video from the double homicide. Our Shelby Township Tactical Response Unit went into action. Our team made the location with the search warrant in hand. We executed a no-knock warrant that was signed by the magistrate, and we immediately went into the room and arrested Sandals. Laying in bed with Sandals was a handgun. He had another handgun on the dresser of the location. Cash that was stolen from the location was also recovered. We did have assistance from the Sterling Heights Special Response Team also. We have a great relationship with them, and they sent 4 of their operators to help us, and they were there stationed outside of the motel in case the guy jumped out a window, which we've experienced before, and we'd like to thank them for that. The suspect was placed under arrest exactly at 5:58 a.m. I mentioned that the guns were in the room with him. One was laying right in bed with him. We did recover other evidence linking him to the double homicide. At this point, I'm going to turn everything over to Mr. Peter Lucido, the Macomb County prosecutor. And Pete, where are you? I didn't mention this.
I'll take care.
Okay, right here.
Thank you, Chief. Welcome, everybody. Good morning. I'd like to first tell everybody thank you for being here, but also a gratitude should be owed to not only Sterling Heights Chief, but the Romulus Police Department, Utica Police Department, and the Michigan State Police and the FBI for their assistance in this case. Undoubtedly, it takes an army to bring somebody to justice. Terrence Sandals was arraigned on Monday, yesterday, in the 40 Wayne A District Court. He's held without bond. These are the charges that were authorized and issued by the Macomb County Prosecutor's Office. There's 2 counts of homicide in the first degree, premeditated, life without parole, 6 counts of weapons, felony firearm. This individual has a lengthy record out of Texas. Also, there's a felony warrant for him that's out there and is outstanding, and they probably will extradite him once we get the governor's warrant. There's 2 counts of armed robbery and 2 counts of possession of firearm by a felon, 1 count of carrying a concealed weapon, and habitual fourth, which is any term of years up to life. These are very serious charges. These are very serious in nature, and to have it happen here in our neighborhood, as well as here in Macomb County, it's not just troubling, it's tragic. The loss of 2 individuals and their families that have to suffer as a result of this. So again, thank you, Chief, for all the hard work, and everyone who was part of this. Thank you for doing what you do every day. And right now, I think we are going to take questions, Chief, at this point. Any questions by any of the news media that's here today?
Any idea or evidence that this guy was going to skip town, being found at a hotel near Detroit Metro Airport?
No, we don't believe so. He was actually living out of the motel at the time, hotel.
What, can you share what brought him here? Meaning, how long he was here? I mean, at first blush to a layperson, somebody from Houston, and then coming to an apparent nondescript car dealership in Macomb County. You mentioned previously having an argument over a vehicle. I mean, why was he here, to your knowledge? Did he have a previous relationship with them?
Yep, so my understanding is that there's an active felony warrant, so he was fleeing. All his crimes he's committed in the past have all been in the Houston area. So when this new warrant for his arrest, which he's aware of, we believe he came up to Michigan at that time. Now, he also, I mentioned he bought a vehicle from the Star Auto before, and then they had a dispute. He thought it was a lemon. They went back and forth arguing about it. And at a certain point, he just dropped the vehicle off, correct? And just left it there.
So that was the impetus then of what happened?
100%, yeah, yes. Let me clarify something. He didn't go in to rob. And this was no hit. He went in to kill that man, to kill the owner. And then Mr. Baban just happened to be there at the time. So
was Mr. Baban a friend of
he's a friend. I shouldn't say interested. We believe that he was there to purchase some vehicles from Mr. Batu.
So he was a customer?
Yes, yep. They had some kind of relationship because they're in the office, obviously very comfortable, so, yes.
You talked about extradition potentially, but wouldn't homicide in Michigan be a higher charge and more?
Yep. Let me first start off by saying that we totally had 15 charges yesterday for the arraignment. We have withdrawn 2 of those charges. One was the drug charge, even though the drugs were present at the time of the arrest, and also a felony firearm that goes with it, the 2-year. They all run consecutive in nature. So it's down to 13 charges at this point that he will be seen. It's because another agency that's involved, a task force, is more interested in those drugs that were found, and they'll be looking into it, but there's no telling whether or not we're going to rejoin those charges at some time. Like anything else, when a case is under investigation, it's ongoing, innocent until proven guilty in the court of law. This man has every right to be presumed innocent based on the nature and circumstances, though it's no bond means something here. In addition, I want to tell you about the extradition. A governor's warrant is necessary for the state of Texas to take this individual and have him extradited back to the state on the open warrant, on the open felony warrant. And he has assaultive nature crimes, so I'm sure they're going to be looking for him. But you're absolutely right. The murder charges both carry with it life without parole. It would be futile, if you will, to go back on a charge that doesn't carry life.
So forgive my ignorance, I don't need to grind it to a fine powder here, but why would that even be a consideration when he's wanted for premeditated murder here?
Okay, number one, that warrant had stayed out there and they put it in lien in their own system in the state of Texas. Number two, they have every right to them, like anyone else that has rights to individuals that have committed crimes in their state or in their county. As a result, if this case, for whatever reason, is concluded, they may not need it at that point, just housekeeping rules, which is they would go ahead and do a plea by maybe even over Zoom.
Can you describe Mr. Sandals' connections to the Detroit area? Why was he in this area? Does he have family here?
We're still investigating that, but like I said, what I think, and I think some of my men agree with me, that he was fleeing Texas, had some kind of connection up here, but we're still looking into that.
He was working in this area?
Yeah, not legitimate work, a different kind of work, if that makes any sense, so.
The quantity of cocaine, are you able to say, large amount, quote unquote?
It was enough to charge him with distributing, but we're not going to do that right now, and the prosecutors are working through that. Not to say we're not going to come back in the future and get a warrant, but right now, the prosecutors have decided not to do that.
And if you don't mind, a couple of timeline questions. To your knowledge, how long has he been in Michigan and at the hotel? And it was 2 weeks, 3 weeks ago that he purchased the car and was upset about it?
The vehicle was over a month ago. Brandon, can you answer those questions, please? 5 weeks. Okay, 5 weeks he purchased the car.
Right.
And then there's a discrepancy about, he's saying something different, how long he's been in town, and our investigation's showing he's been in town longer than that. So we're looking into all this right now.
I don't mean to monopolize, but it also struck me as why would he come all the way to Shelby Township when there's plenty of car dealerships in Romulus and Wayne County?
Good question.
Yeah.
Good question.
Do we know?
No, we don't know. In fact, if anything, all these pieces that we have clearly give a picture of what has happened, but every little nuance that's being asked, we're looking into still.
There's one more thing I want to add too. Our SIU detectives, they went in like super sleuths. I've read cases before where these young guys now with their technology, they went in and they were able to access our Shelby Township Special Investigations, and our detectives under Lieutenant Dowdy were able to go in, grab the server, pull the video up immediately. Like within minutes, we saw the whole thing would happen. And this is, I don't even think I could pull the server up in my own house, if that makes any sense. So I was beyond proud of them. These guys trained for this. We're prepared. Our 4 pillars of our police department are preparedness, which our men were, and women. Pride, which we take great pride in protecting Shelby Township, keeping it safe. Professionalism, which we strive for daily. And incredible, outstanding teamwork done by our men and women of the police department. I've been doing this for 39 years now. All 3 counties, 3 major police departments. I don't think I've ever been more proud of my staff in my life than I am right now.
Any other questions?
Can you reveal how much cash was stolen? Any other items were stolen from the facility? Cash that was in the, I assume it was with the business that Mr. Sandals allegedly stole?
I didn't hear the question.
The amount of cash that Mr. Sandals stole from the business?
The amount.
Of that, and were there any other items stolen?
The cash only was stolen. Do we want to give that out? No, we can't give that out. Not now. We're still, like I said, I'm probably saying too much.
Assuming the firearms that you found at the hotel, that was the one used in the crime.
And the murder weapon was recovered.
I guess he just answered the question.
I'm a family member. Can I have one question?
Yeah, of course.
Okay, you said there's an open warrant for him in Texas.
Yep.
So he's carrying all whatever he had here back with him to Texas, so you guys transfer him to Texas?
Let me
Go ahead,
take
Pete,
it.
please.
Yeah, and I'm sorry about your loved one who's been lost. I truly am. After reviewing this information and seeing what happened, it is horrific. So sadness goes out, but our hearts go out to the family.
So he's transferred to Texas?
Okay, he's not transferred to Texas. He'll be sitting in the Macomb County jail until we get this case resolved. He will be staying right here. A governor's warrant won't stop our prosecution and furtherance of this case in its making. As a result, After this case has been concluded, then, and only then, will they have rights to this prisoner.
So, if possible, can be transferred to Texas. They have everything, whatever got here, transfer with him.
No, that doesn't, the crime was committed here in Shelby Township.
Okay.
As a result, Shelby Township has the jurisdiction and will be prosecuting this crime to the fullest extent of the law.
Thank you.
Any other questions?
How many homicides in Shelby Township? Is this the first one this year?
No, that's a, so I've been a chief here for just under 11 years. My first 5 years, we had one total. I think I was 4 or 5 years into my career, one total in 5 years, and that was a domestic. So tragically and unfortunately, just since June, we've had 5 already. And there's one more thing I forgot, to be remiss if I didn't mention. Our Board of Trustees, they've given us everything that we've asked for. We have 50 flat cameras positioned around the township to keep our township safe. In other communities, they don't like this. We love our flat cameras. Our residents want our flat cameras here, and so do our business owners. We've solved countless crimes with these cameras, and our board members have done this. All our equipment, our gear, everything I asked them for. Rick Stathakis is in the back of the room, our township supervisor, they give us. And I have to say that because I know what goes on with my colleagues around the area, and they get told no repeatedly. We don't get that here. They want us to keep the township safe, and that's what these men and women of our department do for us. Mr. Lucito's a resident here in Shelby Township. I text him first thing Saturday morning, if you saw the work that our staff did, you'd be so proud. And they called and blew my phone up immediately, telling me the same thing. So I said, I can't express enough how proud I am of our team. These guys, they care, they're skilled, they're professional. I was amazed how quick they were able to pull the video up. Please. Please. Oh, I'm sorry. And one of our other board members is in the back, Lisa Casali, and I mentioned John Vermeulen already over here to my right.
Just to be clear before we go, this is apparent retribution for an anger over a $3,000 vehicle.
We can only suspect what it is. We can only, envision what it was based on the representations and the facts in the case, and the car being left there, the vehicle.
I'd like to call up real quick our township supervisor, Rick Stathakis. He's been a township supervisor since 2008. Boss?
Yeah, thank you very, don't go anywhere. Thank you very much. I just want to say on behalf of the Board of Trustees and all the residents in Shelby Township, we want to thank and congratulate the entire PD. You guys have just done a great job. Pete Lucito's always been here, and I see we've got Ron Robinson as well, our representative. But I just want to say, yes, thank you, congratulations. But when we solve these cases, we kind of move on, because that's what we're supposed to do. But I see we've got a family member in the back, and I just want to say to the victims of the families of these victims, we continue to pray for you. We know that you will be grieving forever, and we will not forget this, and we continue. You are in our prayers, and we want you to know that. Thank you very much.
Thank you, sir.
Yeah.
Robinson, I think
Go ahead.
Mr. Robinson?
Yeah, I'm just extremely proud, and the quickness and this was resolved, and the police work is just second to none in Macomb County as far as I'm concerned. But again, it's teamwork. So I'm glad that there's other municipalities involved, and I could just not be more proud of the work that they've done here. Shelby Township, Sterling Heights, they're safe places. Warren, they're safe places. So if you commit a crime here, you're going to face justice. So thank you for your hard work to get this done so quickly.
I want to address the Channel 7 gentleman in the back. I want you to know that we've gotten arrest warrants on every case. We've solved every one immediately.
Is there any speculation on why there's been so many this year?
Yeah, we've talked about this, beat it to death. Crime has no boundaries anymore. And when criminals think they can go unpunished and walk out the next door, they go anywhere they want. And it drives me crazy. And we're vigilant on keeping this township safe, and we do everything possible to do that. Some of the stuff, there's nothing we can do about these domestics. This, I don't know how we could have stopped this. We were forced to, my deputy chief made me watch the video this morning. I don't like to see this stuff, okay? I've been dealing with it my whole career. I have young kids at home, and I made Mr. Lucito watch it also. and we debated on showing it here, and we went. Yeah, I'm sorry. Bottom line is we're going to save it for trial. That's the bottom line. We're going to save it for trial. It's very upsetting. Out of respect for the family. I mean, they're going to have to see it eventually at the trial, but we're not showing it. We're not going to allow it.
Any other questions? Thank you all for coming.
Thank you.
Press conference in which they were discussing the man Terrence Sandals was arraigned on 15 felony charges, including first-degree murder and armed robbery, for the fatal shootings that happened at Star Auto Sales on Ryan Road. And once the story gets to trial, you can be sure the Bethea'S Byte Reloaded is going to cover it. All right, ladies and gentlemen, that's gonna wrap it up for the docket. There's only one thing left now, and that is my closing argument. As we wrap up this edition of Saturday Night's Main Event, the common thread is clear. Choices have consequences, and justice demands a reckoning. The courts have spoken, but our role is to remember. Remember the victims, remember the families, remember the dignity of every life. Tonight's headlines remind us that justice is not only about punishment, but it's about preserving truth. May we leave resolved to live as witnesses of integrity and accountability. I want to thank you all for joining me here tonight on this edition of Saturday Night's Main Event. This has been a loaded edition of Saturday Night's Main Event, and I hope to do more in the future, loaded or not so loaded. I'm Ernest Bethea, the Last Outlaw. Again, thank you all so much for joining me here. Thank you all so much for the support, and I can't do this without you. So until we do this again, remember where you are, the trauma-free true crime destination. This is Bethea'S Byte. And of course, it's reloaded. Thanks for joining me.
Thank you all for joining me here at the drama-free true crime destination. Be sure to follow Bethea'S Byte Reloaded all over social media and get your coverage of true crime news with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.